We're going to start with 175, People versus Golo. Counsel, would you like any rebuttal time?
Yes, Judge. I'll go 8 and 2, please.
How many?
2 minutes.
Two. Go ahead. You're on.
May it please the Court, I'm David P. Greenberg for Appellant Golo. And the first thing I'd like to say, because I know there's a lot going on here, is that the statute couldn't be clearer that before a hearing, a trial court can rule on the merits of a DLRA 3 motion, the defendant is entitled to a hearing on the merits.
Even if the judge, as in this case, indicated quite clearly his views on the merits?
Absolutely, Judge. And the reason for that is that the statute, by the wording of the statute, the hearing court, well, the non-hearing court here, didn't have the discretion.
What does it say, Counsel? It
says, after laying out the criteria for determining the merits, the statute says the court shall offer an opportunity for a hearing and bring the applicant before it.
So if you're eligible, you get a hearing.
That's right. Now, right after that, there's additional language that informs that reading, not that I think it's required. It says the court may also conduct a hearing if necessary to determine whether such person qualifies and to determine any other controverted issues. So,
guys, why have it be a discretionary choice on the controverted factual issues related to the sentencing? Why is that not mandatory in the hearing? I find that confusing. I understand the discretion on a hearing regarding eligibility, but if there are truly controversial issues related to the sentence, why is that not part of what you're saying is the required hearing? Or the hearing that your client can request has to have an opportunity to say, I want that hearing.
well, he's entitled to come before the court and present evidence, and especially to have his say. I think that the second part of it primarily focuses on the issue of eligibility, which, to be honest, often isn't, as far as the facts go, really isn't controvertible. I mean, usually there's documentary proof about the defendant's record, and there isn't necessarily a need for an evidentiary hearing because it can be determined on the papers.
No, I get that, but it says any controverted issue of fact relevant to the issue of sentencing. It strikes me that would be part of the first, right, the other section in Section 23.
Well, I think that makes clear that beyond the defendant...
Isn't that there's any fact that's in dispute, maybe it's part of the hearing, maybe it's not, but once you resolve those facts and the judge is satisfied that the person is eligible for resentencing, the hearing that we're really talking about that your client would be entitled to is the hearing on, I'm now going to make a decision on this resentencing request.
I'm not sure.
Well, I just don't understand I understand, as I say, the discretionary hearing on eligibility. I'm not understanding on these controverted issue of fact relevant to the issue of sentencing.
I think it's probably just a general catch-all phrase, because in practice, and I think probably as anticipated...
That might be helpful. What's the practice?
In practice, these resentencing hearings, and our office was one of the primary assigned counsel on these in the city. We did hundreds of them. Mm-hmm. Normally, it's very similar to the sentencing hearing that happens after a guilty plea or after a conviction. Mm-hmm. The judge generally wants to hear from the defendant, wants to see what the defendant looks like, what his bearing is, what his attitude is. And I don't remember, to tell you the truth, a situation where we called witnesses and so on, but we did find, and the trial-level cases that I cited in my brief exemplify this, but there's many more situations that didn't result in a written opinion that, we did ourselves. Judges want to hear from the defendant. They want to see what he looks like. They want to hear what his or her attitude is.
Is that why, counsel, the statute says that the defendant shall be offered an opportunity to be heard, because it's the defendant's choice to come forward, right?
Right. There may be situations where on advice of counsel or just on the defendant's own decision, just as with regular sentencing after a conviction, defendant doesn't want to speak or counsel thinks it's better to rest on the papers. So they don't have to do it, but if we want it, we're entitled to it.
Are you saying, though, that upon the filing of a motion, you're automatically going to have a hearing?
No. I mean, I'll concede that the court doesn't have to hold a hearing if on the papers and there's no controverted issue, the defendant isn't eligible. The hearing comes in once there's a determination of eligibility. But once that happens, once the case is in play, the defendant's entitled to a hearing. And I just want to emphasize one thing about that. You were asking me about controverted issues and so on. What the defendant has to say, how he comes off, what the judge thinks of him is always a controverted issue. A defendant may have a poor record, but he's still entitled to have the judge assess him and weigh that against his documentary record.
So when you say the court shall offer an opportunity for a hearing and bring the applicant before it, are you saying that on any motion there must be a court appearance by the petitioner?
No, I think that if the issue of eligibility can be determined,
Well, it's only when he's resentenced, right? You're not asking for more than that to follow up on the judge's question.
no.
No, because this is it's like any other sentence. Isn't that your argument?
That's the point.
In essence, that's the core of your argument. But you have to be eligible first. Let me just take a step back on the eligibility. It seems under the analysis that you're presenting on the look-back period that this would, in essence, eliminate 8 of the 10 years of the look-back period that we'd actually have to look at. There would only be 2 years of conviction-free behavior for the court to actually look back on. Is that correct? Am I reading that right?
That's the way the statute's written, Judge.
I have to admit, I struggled with the reading on this. I went over it carefully a number of times, and my clerks pounded it into me that this is the way that this is your analysis anyway to try and make sense of it. But it seems that it's hard for me to see how the legislature would devise a reading where, in essence, a post conviction felony could serve as a predicate and essentially eliminate a look back for 8 of the 10 years. In this instance, whatever it would be in another case.
I'd like to talk about that. I'd also like to talk later about why I don't think the court can even reach that issue.
Go ahead.
That we won in the appellate division. But just on the merits of that, start with the language, and then I'll get to the policy. I think the language, I know it's a long sentence there. I mean,
But just so I'm clear, you're relying on a sentence where between the time of commission of
Right.
the previous felony, that language?
That's right.
Okay.
The reference to a previous felony doesn't make sense if the felony that we're talking about
And the time of the commission of the present felony.
postdates the present one, which can only refer to the drug crime on which the resentencing is sought. And whether you think that it was a good idea or not, or struggling to find a reason for it, that language is it may be convoluted, but it's clear and it's convoluted.
Can I ask you, when you say postdates or predates, are you talking about the date of commission of the act?
That's
or
what it refers.
Conviction of the act? You're talking about
That's
commission.
what it refers to.
Okay.
It refers to how the commission, how they line up in terms of commission. But as far as the reason they may have done it, there are plenty of things that judges typically take into account in in determining the merits of these motions that happens after the date of the drug crime. Institutional record, misdemeanors, for example, that aren't covered by the exclusionary
Well, you're saying
language.
the look back goes to eligibility, but a judge can always consider your criminal record.
Absolutely. And so the judge, if there had been a hearing and if my client had gotten to have his say and the judge saw him, the judge should have found him eligible, could have considered those post-drug crime robberies.
So you're saying your interpretation is, I think you're arguing, your interpretation is in line with the legislative intent to cast a broad net in terms of the class, but doesn't in any way preclude the judge from exercising discretion and determining whether or not this person indeed should be resentenced based on their criminal history.
Absolutely not. Well, absolutely yes. The court would, I'm sure, look, as it did, not in the right way, look at these post-drug crime robberies but they're not disqualifying because
Okay,
of the
counsel,
language.
let's hear from your adversary.
Danielle Fenn for Respondent Richard A. Brown. May it please the Court.
Counsel, assume that defendant is eligible. Doesn't he have to have a hearing?
Your Honor, in this case, a hearing was unnecessary. The statute says that the Court shall offer the opportunity for the hearing, but then in the next sentence it says the Court may also conduct a hearing if necessary to determine controverted issues of fact and determine
So
eligibility.
when is a hearing necessary?
It's when
It's
it's
never
a
necessary?
it's when there's controverted issues of fact.
No,
and here
it
there
says
wasn't.
may if it's controverted issues of fact. That's what
Yes.
that's what the language says. So how could it say that must offer an opportunity for a hearing and then say may if there are controverted issues of fact? Doesn't there have to be some situation in which it must be a hearing?
In this situation, the shall and may, it's ambiguous. But that sentence with
You
the
really
may.
think the input of the statute is ambiguous?
This language
Read
is.
the first sentence. I mean, doesn't that say it all?
This first sentence is informed by the second sentence.
Yeah,
It's
but
shall
the
and
second
then may.
sentence, I think you're really stretching in terms of that. You mean on the merits, you don't need a hearing? That's really your interpretation of the statute?
Your Honor, it says that.
I know what it
yes,
says. I've read
yes.
it the same way you have.
Yes, Your Honor. And it's clear that it's necessary if there's
It's
converted.
not clear to me that what you're saying is right in terms of the statute.
According to the language of the statute, it's may.
Okay, but let's try it even under your reading. Why does that exclude the prior sentence saying shall, meaning shall?
It shall offer the opportunity, and then
Okay.
it goes on to explain when a hearing is necessary, what the purpose of a hearing is.
No, because you're deciding to excise the word also. You're reading it may
May
conduct.
also.
It says may also. That
Yes.
in addition thereto. So we're starting out with the first sentence, shall offer the opportunity. If his client wants it, that's the opportunity, you can move ahead with the hearing. Client doesn't want it, don't have to go ahead with the hearing. The court may also, so now these are other circumstances, other opportunities during which the court has the discretion to decide, I want to proceed with the hearing, I believe the hearing will be helpful to me. That's on the eligibility, that's on the controverted issues.
Yes, if the defendant
How does
wants
that,
a
I was going to say,
hearing.
how does that change the first sentence? We're all sort of
Seems
back to
like,
that.
it seems like the statute reads to say, if there's a question of eligibility, the court may conduct a hearing to determine whether or not you have a question, to satisfy himself on eligibility. But once you're eligible, you shall bring the person in for resentencing. That would be the way I would read it.
In this
You
case,
see what I'm saying?
yes, Your Honor, there's the shall and then the may, and even
I
in that
understand that, but they refer to
situation-
two different situations. It's a two-pronged analysis. Before, we were talking about how you can have a look-back period and whether or not he'd be eligible. The eligibility question is separate from the sentencing question. The court may conduct a hearing on eligibility, but you shall sentence anyone as you would sentence them in any other situation. They have to be present and have a right to speak at their own sentencing.
Your Honor, this is very different from a right to be present issue, because he wasn't sentenced
See, I don't
and he
know if it
wasn't
really is. I think
resentenced.
policy-wise, it seems that the legislature seem to be saying that while it is a resentencing, it's still a sentencing, and that's kind of a special right. You don't put people away without having them have an opportunity to say something.
A defendant definitely has a right at a sentencing or resentencing proceeding. Here it's a decision on a motion. His claim of error is that the court decided his motion without a hearing, and defendant could have moved to re-argue and alerted the court of this error, the procedural error, which he's now claiming is that he didn't have a hearing, and the court could have rectified that, but that didn't happen, and as the appellate division held,
Yeah,
it's
but
unpreserved.
Supreme Court here held two things. First, that he was eligible, they held two things, that he wasn't eligible and that substantial justice dictated that he not get it anyway. The appellate division said he was eligible, but substantial, and agreed with Supreme Court on
Yes, Your
substantial
Honor.
justice. So you see the problem. In Supreme Court's initial ruling, they did both the may and the shall when they should have only done the may and not the shall.
Your Honor, the Supreme Court correctly decided this motion on the papers. The issue of eligibility, and there weren't contested issues of fact. everyone agreed basically on the facts. Both sides included the same papers. It was the conclusions to be drawn from
So should the
those.
appellate division then, once he was eligible, at least remitted it for a hearing?
No, Your Honor, that
Why
was
not?
not necessary, because the court properly considered, the appellate division properly considered the substantial justice argument. And the court and the appellate division actually looked at the entire record. They noted his efforts at rehabilitation, that he went to different programs.
What about that intangible factor of having the person before the court and having him, his demeanor and his attitude and his sincerity, or any other intangible factor viewed by the court? Isn't that what the purpose of the requirement for an appearance is?
No, Your Honor, shall offer the opportunity, but the court, that was unnecessary in this case, and it could be unnecessary in other cases as well. Not every defendant might want a hearing, and
So
here there
shall
are
doesn't mean
contested.
shall? I guess we're back to that.
It's
But
shall
that's not the
opportunity
case here,
hearing.
because he wanted the hearing. When else wouldn't shall be shall?
It's, again, it's the two sentences. In this case, as to he wanted the hearing. In this case, defendant points to that he would be able to come alive for the court, but there really is a form.
No, but let me say this. I don't think the question is whether or not we think it's a smart idea for him to choose a hearing. It's what the language says. It's not for us to determine whether or not that's a good idea for the legislator to have written it this way, or a good strategy for his client to decide to appear. The question is, what does this language say? You may think he gains nothing from this, or the judge would not benefit from this, but it's what the language says.
Yes, Your Honor. And again, it's shall offer the opportunity, but may also conduct a hearing. And it's that part after, if necessary, to determine
Also, if
controverted.
the eligibility has to be determined first, wouldn't you think that the court, it would say the court shall determine eligibility and then decide whether to conduct a hearing or may conduct a hearing based on the eligibility? I'm a little confused about why you think that the second sentence controls the first sentence.
These should be read together. It's may also conduct a hearing. And it says shall offer the opportunity for a hearing. It's ambiguous in the sense that one says shall and one says may.
Doesn't your interpretation lead to the possibility that a judge says, I'm not granting hearings on any of these things because I think the DLRA was a dumb idea. So if somebody wants to apply to me for one of these hearings, the answer is no.
No, Your Honor.
What would you do if they said no? Who has the right to appeal and under what grounds?
In that situation, the defendant could move to re-argue or could.
I say no again because I don't believe in the DLRA.
And the defendant could also appeal to the appellate division.
On what grounds?
That, well, it depends on what the.
Well, your argument is that he's not entitled to a hearing anyway. So I'm exercising my discretion to say no.
Is the ruling, the lower court ruling, as in this case, he wasn't eligible and substantial justice dictated? It would be the same situation. He could appeal, like this defendant received an adverse ruling on the issue of eligibility and substantial justice. He appealed that to the appellate division, and he also raised his hearing claim. His hearing claim, the appellate division held his hearing claim was unpreserved.
Well, your argument, though, even if he'd raised it, is that that's not a valid claim because that's all within the province of the court.
No, Your Honor.
Oh.
The May sentence talks about when it's necessary to determine the hearing, and there's controverted issues of fact. And the court, the defendant in your hypo could appeal it to the appellate division. In this case, that's what happened. There was a determination on eligibility and the merits, and the defendant appealed to the appellate division.
I picture a lot of cases. This is, of course, they're all unique, I suppose, but there are a lot of people, I assume, who've already served their sentence under the DLRA, have led a law-abiding life, but they're stuck with a sentence, and they want to get it taken care of. And they have this opportunity, so they can file a motion. And this seems to be a very welcoming statute, and that's why the language is the way it is. You have a right to appear, and you can say, Judge, I was convicted 15 years ago, and I'm trying to get a promotion at work, and this thing is stuck in my, so I'd like to get it done. And I don't think if I was a judge, I could say, well, I don't believe in the DLRA, so you're denied. I would think that you have a right to appear and explain yourself, and then a decision could be made. That make sense?
Yes, Your Honor, the white light is on. May I respond?
Yes, sure.
In that case, in the DLRA, there was an ameliorative intent, but there are also requirements in terms of eligibility and the substantial justice prong. And a court considering these motions should consider both. It's not that everyone is eligible. In the specific instance in regard to the eligibility argument, the court could have, the legislature could have easily said everyone's eligible and then substantial justice, but the legislature said no. Violent felons should not be within the 10 preceding years following this court's decision in Sosa, should not be eligible. So in any DLRA motion, there's both the eligibility and the substantial justice prong, and the court should consider both and follow those procedures. And, of course, the defendant would have the remedy of an appeal to the appellate division.
One last
Just
question, Judge
very
Rivera.
quickly, why is he not eligible? Just very quickly.
Your Honor, because of the two exclusion offenses. This court's case in Sosa said that the preceding 10 years starts at the filing of the motion when there's a resentencing motion. And the definition of exclusion offense is violent felony where a defendant or person was previously convicted within the preceding 10 years. That total phrase, starting from the resentencing motion back, would include these two robbery convictions, the first-degree robbery convictions, and thus defendant would be ineligible for resentencing.
Okay. Thanks, counsel.
Thank you.
Counsel Rebuttal.
The one thing I want to really emphasize, because I didn't get to this in my main argument, is that I think it make it a little easier with the whole eligibility thing in this case. I don't think the court can reach the issue of eligibility here. I've covered that in sections in each of my briefs, and I specifically emphasized People Against Caracedo, which came to this court after an affirmance in the appellate division, just as this case did. And the question there was what the relief should have been in the appellate
And the
division.
people did not cross-appeal. Is that basically where you're going with this, counsel?
I don't think they could have cross-appealed, but
Because-
the problem is that the only issue in front of this court is what our relief should have been in the appellate division. And they can't come in the back door and take that issue away by arguing eligibility,
Favorable.
because that'll give them affirmative relief.
Okay, counsel. Thanks. Thank you both.